Welcome and thanks for joining us on Zoom tonight. We have the privilege of hearing from 5 remarkable and distinguished guests, 2 of whom will be our host, and the other 3 will be our guest speakers of the night. Before I start, let me first briefly introduce myself. I'm Charlotte, the Pro Bono Officer of the UCL Law Society. The UCL Law Society has organized pro bono at the bar events in the past few years, but I believe this year's pro bono at the bar is the largest of all, because this year we have LSE and Cambridge University's law societies working with us, and we're very grateful that despite COVID, this collaboration still works out very well. So now, without further ado, I'm just going to pass on to the LSE Pro Bono Officer.
Hi everyone, by way of introduction, I'm Charmaine. I'm the Pro Bono Officer of LSE Law Society. It has really been such a big pleasure, working with Charlotte, Amelia, and Jody for this event. And we are so happy to have all of you here with us and taking, precious time out of your Friday nights to be with us and listen to, pro bono initiatives organized by Law Society. So we really appreciate all of you. And I think secondly, I just wanted to extend my gratitude towards Jody and Lord Sales and all our speakers for also taking the time out on a Friday night to share their wisdom and knowledge with us. So I'm hoping that this will be a great session for all of us. I will pass it on to Amelia to introduce our lovely chairs. Yeah.
Thank you, Charmaine. Welcome, everyone. I'm Amelia, and I'm the Head Pro Bono Coordinator at the Cambridge University Law Society. We work with multiple pro bono organisations such as Amicus, Citizens Advice, the International Law Book Facility, and the Access to Justice Foundation to deliver pro bono opportunities to students and to help improve access to justice and legal education. It's been a real pleasure to work with the pro bono divisions of the Law Societies of University College London and London School of Economics, and to be able to join together as organisations that share a commitment and a passion for pro bono work. Tonight's event is the start of a long-term collaboration with the 3 societies, and it's a very fitting way to start. I'm now very honoured to be able to introduce our 2 chairs today. Our first chair, Dr. Jody Gardner, is a university lecturer in private law at the University of Cambridge and a fellow of St John's College. Jody's research is primarily focused on the intersection between private law and social policy. Prior to her academic life, Jody was a community lawyer in Australia and specialised in advocacy against unfair consumer, debt and insurance contracts. As part of her role with the law faculty, Jody assists the Cambridge University Law Society with their numerous pro bono activities and programmes. Our second chair tonight, Lord Sales, is a Justice of the Supreme Court. He studied law at Cambridge University and then did the BCL at Oxford. He discovered that he found law very interesting and decided to try and become a barrister. He started at the bar in 1986. His practice was originally focused on employment law and then moved into commercial law. In 1997, he was appointed as the principal barrister for the government, known as the Treasury Devil. In that role, most of his work was in public law. He argued many of the leading cases under the Human Rights Act when it first came into force. He also argued cases for the government before the Court of Justice of the European Union in Luxembourg and the European Court of Human Rights in Strasbourg. In 2008, he became a High Court judge in the Chancery Division, dealing with commercial and property cases. He also sat in the Administrative Court doing judicial review cases. In 2014, he was appointed to the Court of Appeal, and in 2019, he was appointed to the Supreme Court. I will now hand over to Lord Sales to begin. Thank you very much.
Thank you, Amelia. Good evening, everyone. Thank you for joining us for this session this evening. I'm very pleased to be able to be involved in this event. It's just a shame that we're having to do it online rather than in person. Whenever I can, I try to encourage lawyers to get involved in pro bono work. Doing legal work pro bono is a great way to use your skills and talent to help others and to make a direct contribution to society. When you are a young legal professional, it's also a great way to build your confidence and to develop your skills in real life situations. It provides an opportunity to get real hands-on experience of legal cases and an opportunity to build your reputation. When I was at bar school, rather a long time ago now, I'm afraid, I volunteered for the Free Representation Unit, or FRU, to act pro bono in small-scale cases. It was a good way for a law student to get a taste of what advocacy would be like. I have a vivid memory of my first case. It was an unfair dismissal claim in the Employment Tribunal. My cross-examination was not the greatest demonstration of the art, and in fact, the killer question put to the other side's witness was asked by a member of the tribunal, not by me. But we won, and I felt I had performed a valuable service. I continued to support FRU throughout my career as a barrister. As a judge, I want to emphasize how useful judges find it when lawyers act pro bono for people who would otherwise have to appear to represent themselves as litigants in person. This has two effects. First, their case is likely to be presented more effectively than if they did it themselves. So one can have greater confidence as a judge that one really is doing justice properly in the circumstances of that case. Secondly, it means that the court hearing can be dealt with much more efficiently, which saves time which the judge can then devote to other cases in his or her crowded docket or list of cases. Both these things mean that judges are invariably very grateful to lawyers who appear pro bono. Being frank about it, they're likely to be more friendly and rather less fierce than they might be in ordinary cases. So appearing in court pro bono can be a good way to get used to being on your feet and building up your confidence in court. Going to law is a frightening and stressful experience for everyone, and especially for people who cannot afford to pay for legal assistance. They need help to present their cases, and judges need help too to understand the facts and the arguments that people caught up in the legal system are trying to present. People do not appreciate what an important role lawyers play in getting to the bottom of a case in discussion with their client before the case ever comes to court. Nor do people appreciate how lawyers digest and filter the stream of information from their client in order to fashion an effective legal argument which can be presented succinctly and efficiently in court. But I assure you that judges understand this very well. As a judge at first instance, hearing urgent applications in the Chancery Division, I benefited many times from the work done by pro bono lawyers who provided a service to help out unrepresented litigants. They did a fantastic job. Application days were very pressurized with many cases and not much time. If there were litigants in person, it could take the court a long time in debate with them to understand what their case was about and what they wanted the court to do. There was always a risk that you might not have understood fully in the time available before you had to give a short judgment. When lawyers helped out pro bono, however, you could be confident as a judge that the best possible explanation and submission was put forward. Everything could be done more efficiently in court, so you have more time to devote to the other cases in the list. This also gives judges a warm glow of goodwill towards pro bono advocates when they next appear in court, and that does them no harm when they come before us representing paying clients. Regrettably, the need for pro bono lawyers is increasing. The withdrawal of legal aid in many areas has left more and more people exposed to the legal system on their own and needing help. In the Supreme Court, we often benefit from the work of lawyers acting pro bono in high-profile cases, sometimes acting for the parties and sometimes representing interveners, and we find this very valuable. But I am very conscious that the greatest need for pro bono assistance is in first instance courts and tribunals up and down the country. That is where ordinary individuals come into contact with the law and need help. They need help to understand their rights, and they need help to vindicate their rights against others who may be better equipped than them. So I encourage you to become involved in pro bono work at every level when you get the chance. Pro bono legal work is a good way to gain experience and build your skills. It's a great way to support the rule of law in our country, and it is an invaluable way of giving back to your community and of helping individual fellow citizens. Thank you very much. So I think we're now shifting to speeches from each of the three panelists.
Thank you very much, Lord Sales. So I'd just like to briefly introduce the panelists. They're all going to talk for a quick period of time about their experiences with pro bono, and then we're going to have the opportunity to ask them a number of questions. And at the end, we've got an opportunity for the audience to also ask the panelists and Lord Sales any questions that they might have about pro bono. And if you would like to, please use the question and answer box that's at the bottom of the Zoom screen. So our first speaker tonight is Patrick O'Connor QC, who is a barrister who practices in a broad range of criminal and civil work at Doughty Street Chambers. So thank you very much for joining us, Patrick.
It's a great pleasure to contribute this evening. Yes, so I've been in practice for over 50 years now, and I'm sort of winding down considerably. Some would say over the hill or way down the hill. And I've had a very mixed human rights practice in criminal trials and appeals, inquests, public inquiries, and civil litigation for tortious conduct by state agencies. My pro bono work has included death penalty appeals to the Privy Council, normally from the Caribbean, an early environmental case, which I may expand upon a little later, in 1979, inquests into deaths in custody very often, and contributing to the enforcement of the prohibition on torture under universal jurisdiction. Now, that's the broad range of my pro bono work. In these few minutes, can I just give you a short example of how things have changed? Lord Sales' remarks were extraordinarily encouraging and welcome, but it's not always been thus. And I can remember appearing pro bono at an inquest, and the coroner challenged me, and actually challenged me for behaving improperly and unprofessionally for acting pro bono without a fee, because he drew the conclusion that I must therefore be acting for some personal improper motive or commitment to the clients. And of course, that is a ridiculous proposition, because there is commitment in doing pro bono cases, but it's commitment to a principle of access to justice and equalizing or correcting an imbalance of resources between litigants, especially, for instance, at an inquest. The professional duties, and this is to be emphasized, remain absolutely the same. You give the same objective professional advice to your clients, totally unaffected by whether they pay you or they don't. That's a very brief summary and an example of how we are rather more fortunate now than we were perhaps 30 or 40 years ago.
Thank you very much. I'd now like to introduce our second panelist, Deirdre Fottrell QC, who's a barrister who specialises in the law relating to children and who has a broad experience in public law cases at 1GC Family Law Chambers. Thank you very much.
Thank you very much. Let me start by saying that two things have really impressed me in terms of the organisation of this event. It's very impressive that there are such things as pro bono officers at law societies, and maybe I'm showing my age by saying that, but certainly when I was at university, the opportunities to get involved in pro bono work are very limited, and it's really heartening, if I may say so, to see that there is that level of commitment and that level of organisation. And the second thing is, it's not surprising that I'm available on a Friday night to participate in a talk like this, but I'm very impressed with the dedication of student body being available to attend a talk like this on a Friday night. Let me say a little bit about my work and why I found pro bono work to be important. I work primarily as a family lawyer, and my main area of practice is in the law relating to children. And I'm very often dealing with clients in public law cases who are facing removal of their children, or relatives who are seeking to care for children, or sometimes individuals whose children are being placed for adoption against their will or without their consent or agreement. So we're dealing with an area of the law where the most fundamental rights are at issue. And what is striking, I think, over the 20 years that I've been in practice, is that when I started, pro bono work was relatively infrequent in the area in which I practiced, because legal aid was available right across the board and much more generously available for appeals, for family members to intervene. It's somewhat depressing to note that in my 20 years in practice, the amount of pro bono work which the bar is invited and expected to undertake, and the bar does undertake, has increased very significantly. And what I found very concerning is that pro bono work very often involves fundamental issues, points of law which have to be argued at appellate level, and requires representation, because without it, family members simply wouldn't be able to run their cases. So I think it's helpful for us to think this evening about why we do pro bono work, but I think it's also to be conscious of the fact that there is an increasing demand for pro bono work because of political decisions in relation to funding. And that's something I think as lawyers we all have to be alive to. So we provide a service by stepping in to do things pro bono, but there are also wider issues about representation. I think it is, I would echo the observations made by Lord Sales as to the role that students and law students and trainee barristers and junior barristers and solicitors at the early stages of their career, their fundamental and vital role in pro bono work. Because while a lot of the work that someone like me would do at this stage of my career is appellate work, and I'm very often asked, once a week, twice a week, I will get an email either directly from a member of the public or from a solicitor or a colleague asking me to become involved in a complex case and to act pro bono. The reality is, as we see from emails that we get from advocate on a weekly basis, that around the court in daily disputes at all lower levels, if I may, first instance decisions, there is a huge demand for pro bono. And that presents a real need for those of you who are at the early stages of your career and who are training and getting to the practice stage of your career. There presents a real need for you to become involved in that kind of work. It's also, we're at this stage, all of us, whether we're practicing for many years or whether you're starting out in your career, when you want to think very carefully about what your role as a lawyer is and the opportunity that it provides you with to help members of the public, to assist people when they go to court. And one of the things that I never forget as a barrister is that every single client that I meet every single day, they're having the worst experience of their lives. They're fighting for their children. They're fighting for the safety and the security of their family. They may be putting themselves forward to adopt children. And so your role as a lawyer is to do what you can to make that process smooth, to make that process as straightforward as it can be, but also, as Lord Sales has observed from a judicial point of view, to help the court to make the right decisions, to provide the court with the information it needs, to provide the court with the evidence. And so at the early stages of your career, when you're not perhaps as sure or you're exploring the areas that you might be interested in, pro bono does provide you with a fantastic opportunity to step forward and to use your skills and your knowledge and your learning as lawyers and to help people to present their case. There's many reasons why we decide to be lawyers, but most of us are motivated by a desire to make things better for people and to make things better for our clients. And if you can step into a situation and act pro bono for clients where they would otherwise be unrepresented, then it's an enormous privilege to have the chance to do that. When I was training to come to the bar, I worked as an academic for a number of years before I went into practice. But when I was training to come to the bar, one of my lecturers at bar school said the best way really to find your feet as an advocate is to join FRU and to do those early tribunals and that early work. And it is enormously challenging when you get your first brief, but it's a wonderful opportunity for you to learn. And it's a wonderful opportunity for you to do that thing which we all want to do, which is to help and to assist clients and individuals to present their cases to the court. So I think we're all increasingly aware at the bar, as funding issues have become more acute, we're all increasingly aware of the obligation that we have to take on pro bono work. I never shy from trying to interest junior colleagues in pro bono work. I never shy from trying to interest senior colleagues in pro bono work. And sometimes it also has the advantage that you yourself become involved in interesting cases. I've appeared in the court, the Supreme Court, I think a number 6 or 7 times, and I've never yet been paid for my work in the Supreme Court. It's all pro bono. You can come into a case for a charity or a lobbying group, and you're on the sidelines participating in a very interesting, important discussion and the development of case law, which is going to stand for generations and which shapes people's lives in all sorts of areas of practice. So it also provides you with that opportunity that while you're doing something that is helpful and useful to others, you're also perhaps doing something which is interesting for yourself. So I'm happy in our discussions perhaps to talk a little bit more about some of the work that I've done, but I'm keen, if I may, to encourage and invite you all as you acquire the wonderful skills that you're getting at law school and as you make your decisions about where you're going to go in practice, to see pro bono as an opportunity, not just for you, but also for those individuals that you're helping. Thank you very much.
Thank you very much for those words. And I really do appreciate the fact that you've highlighted the need for pro bono isn't inevitable. The fact that we've got such an increasing demand for pro bono is a result of specific political decisions that are being made about what is and is not funded. So thank you very much for those comments. Finally, I'd like to introduce our third speaker, which is Jennifer MacLeod. Jennifer is a barrister who practices in a wide range of areas, specialising in human rights, public and competition law at Brick Court Chambers. So thank you very much for joining us, Jennifer.
Thank you, Jody. As you say, I'm a junior at Brick Court. I've been in practice for about 8 years, so I'm far less grand than the rest of the panellists this evening, and I've got perhaps far more experience in this type of small claims that both Lord Sales and Deirdre mentioned earlier. I have, as Jody said, quite a mixed bag of a practice. I do a lot of public law, a lot of human rights, a lot of competition law, a bit of commercial, a real mix in my chambers, which I think as a junior gives you quite a nice spread of what's going on, and it also introduces you to lots of policy decisions, which is an area where pro bono work often comes into play, particularly in the public sphere. In my practice, I've always seen, and I think this picks up on what Deirdre was saying, I've always seen pro bono work as entirely integral to my role as a barrister. I see it as carrying a public responsibility, and I've always done pro bono work. I think my first ever case as a second six pupil, which in my chambers you don't do a lot of cases on your feet, but I was released to do a social security tribunal in Shrewsbury for a day, and I found it an altogether unedifying experience, but it was very, very, very good for me. So my first ever case was pro bono, and I set for myself in my first ever year of practice a target for the amount of pro bono work I would do per year, which I have always found very easy to exceed each year. But one thing that I think is quite interesting, and it goes back to both what Patrick and Deirdre said about it's interesting to see a shift in this area, is when I started in my chambers, which is it's a mixed chambers, but it's got quite a commercial focus. I hid the fact that I did pro bono work from everyone. I didn't tell anybody about it. I would just scuttle off and do whatever I was doing. And it was not something that I thought would be considered a positive by other members of chambers. Now, either I've grown up or the rest of my chambers have grown up, or something in between the two. And it's been really interesting to see how the conversation on this has really opened up in the last couple of years. And it's now something that I think as a chambers and as a profession, we value as well as expect. And there are problems with expecting it, as others have touched on, and I can certainly expand upon if that would be helpful. But yeah, so far from being ashamed of my public law practice, it's come quite a long way to be invited to a panel with very senior members of the profession to talk about my experiences. I mean, my experiences have, as I say, ranged from going to social security tribunals, going to coroner's courts, up to appearing unled in the divisional court, in the UN treaty bodies. I've appeared in lots of appellate courts, including the Supreme Court while being led. It's brought me into contact with a really wide range of clients, with a really wide range of legal problems, often a wide range of professional problems to deal with. And it's been really challenging, but really quite incredible for my part. I find that some of the most meaningful professional experiences I've had have come from this kind of work. I think it's a privilege to be able to do it. It's a privilege to be able to assist people. And that's, if anything, I think more important than the many practical reasons why it is good for you to do it. It's also, you know, it can be a real joy to be able to use your professional skills in this way, and particularly when you are obliged by the cab rank rule to take any case that comes along. Pro bono allows you a little bit more scope to put your heart into things that you're particularly interested in than I think one would otherwise get in certainly a commercial practice, but in any kind of practice. So I have gone from being a quiet participant in pro bono to a public supporter of it. But I think it is important to recognise, as sort of other people have already today, how it's insufficient pro bono work. In particular, pro bono work often doesn't provide cost protection to clients. So people who would have had legal aid can't bring a pro bono case because they are potentially liable to be subject to a cost order against them. So it's not an equivalent to what was available in the past. I also think it's really important to recognise that legal representation should be a right, it should be an entitlement. And pro bono work is discretionary. It's something that people can choose to do. And I think it's not just only the most sympathetic clients who deserve representation, who might be the ones that are most likely to get pro bono assistance. I also think it's important to recognise that not all barristers can afford to do a great deal of pro bono. For many people, it's a struggle at the bar, and the expectations of pro bono can be quite significant. So I'm very privileged and very lucky to have the financial capacity to do a lot of pro bono, but I recognise that that's not the case for everyone. So I'm sorry to finish on a bit of a downer. I am, as I say, I do think pro bono is a wonderfully exciting opportunity for us, but I do think it's important to recognise its limitations as well.
Thank you very much, Jennifer. I'll take the uplifting aspect of the increasing recognition of pro bono importance as the message coming through from your chat, because that's a lovely way to end the introductions. So now Lord Sales and I, as chair, have a number of questions that we'd like to ask the three panelists. And then after that, we'll open it up to questions from the audience. So as we discuss, please do, everyone listening as an attendee, think of any questions that you might have. But I'll pass it over to Lord Sales for the first question.
So I think the idea is that Jodi and I sort of kick off the questioning, but just to get it going, the main object of this session is for you, the students, to have a chance to ask all of us questions. But I'll set the ball rolling. And ask the panelists, what would you say is the most memorable pro bono project that you've worked on?
Right, I've been asked to go first on each of these questions. So two examples briefly. The first, it can shortly be told, it was a successful appeal against the death penalty. On behalf of a man in the Bahamas, Mr. Farrington, and his conviction for murder was reduced to manslaughter. and therefore he got a defined sentence. And I happened to go to the Bahamas for other work shortly afterwards, and was actually allowed to go to see him in prison shortly before his release, and he'd found God, and he is no doubt now still living a God-fearing life, and of course that's hugely, hugely rewarding. In a more complex way, the lead in petrol litigation, if I can just explain what that was. Some activists in West London in 1978 started litigation without lawyers against the oil companies and the car manufacturers for causing their children to ingest air from pollution from Westway, and for causing them brain damage. And the causes of action were negligence, breach of statutory duty, trespass to the person. And this was a very fascinating exercise. And they brought in lawyers, including myself, to act pro bono. The companies responsible for this pollution, deadly pollution, were much affronted by this and moved to strike out the litigation on the basis that it was vexatious, frivolous, and an abuse of the process of the court. And this was very challenging and absolutely extraordinary arguments about the limits of trespass to the person through particles in the air, etc. And we amazingly won before the registrar of the Mayor and City of London Court. We won before the county court judge. And then the big guns came in. And the petrol company's arguments were quite remarkable. They were, first of all, that the internal combustion engine could not work without these lead additives at all. And secondly, that all this disclosure of all their internal research, etc., would be far too troublesome. And sadly, in a low point for our system of justice, the court agreed. And so we lost, but we won, because the propaganda of these companies had been so effective that they did a sort of three-point turn, metaphorically, and they saw the writing on the wall well before the tobacco companies did, well, much more speedily than the tobacco companies did, and started to market lead-free petrol in 1985, 1986. But the public had swallowed the propaganda and they weren't buying it. They sort of thought our cars will break down. And so these companies actually went to the campaign against lead in petrol, for whom we had acted, to help them to market, to persuade people to buy the lead-free petrol. So we lost, but we won. And that was a quite remarkable case. It's briefly reported. Apparently it's taught in environmental law tutorials in our great universities, and how it's fabulously rewarding to be involved in that. Very adventurous law, very exciting, and ultimately sort of successful.
I think the cases that I would regard as memorable are cases in which I've been able to assist clients either to hold on to their children or to have children returned to them. I did quite an extraordinary case last year, which was an appeal to the Court of Appeal, which involved a couple who were adopting a child. The child was in their care, and then the local authority changed its mind as to the suitability of the placement and sought to remove the child. And it was a very fraught and difficult situation for the family. They were committed, they considered this child to be their child, and they had lost at first instance and didn't have the funds to take the appeal. So we were very conscious of the fact, representing them, that if the appeal didn't succeed, they were going to lose their child. And so for them, it was a very consequential hearing. It involved difficult points of law, which hadn't been litigated previously. And as regrettably sometimes happens, there was a lot of tension and a lot of animosity had built up at first instance. So I think the relief and the just delight of the family members at the outcome. We were successful in the appeal. What was also quite interesting, because I sometimes, at this stage of my career, I appear in an episode of a series and then I leave the episode of the series and I don't know what happens after. And my junior colleague, who, when the case went back to first instance, followed the case all the way through. And I had one of those moments, which happened very rarely in my area of practice, where I arrived back to my desk in chambers, and there was a lovely gift on my desk with a card from the family. And 9 months after we'd done the appeal, the case had come to an end. We don't do our job to get cards and thanks, but it's nice when it happens. But also, perhaps much more importantly than that, is the knowledge that that family were able to resist what the court that subsequently found to be an unjust interference with their family life. And those sorts of moments are quite important, I think, as lawyers. They help us to keep going through all of the other cases that we lose day in, day out.
Goodness, yes, I think I would heartily agree with that final sentence. I think I'd pick two fairly at random, I have to say, but I think they illustrate two slightly different things about what can be memorable about pro bono practice. My first was for the Bar Pro Bono Unit, as it then was, and it was an inquest. It was a 3-week inquest into the death of a baby, Harry Richford, in hospital. And the position before the inquest was that there had been absolutely nothing that could have been differently to save this child's life. And no apologies were due by the hospital to the family. It was a 3-week inquest in right down on the south coast. So me and a friend, a colleague from Chambers, we drove down on the Saturday and we rented a house and we stayed there for 3 weeks. So it's a very intense experience. I had never appeared in a coroner's court before, ever, apart from at the pre-inquest review. I didn't know what any of the rules were. I didn't know how the thing was going to operate. I think we cross-examined about 45 witnesses in the course of 3 weeks, which at our stage of practice was a lot. And it was, I mean, it was quite remarkable procedurally to be going through a process like that, which we'd never been through before, receiving thousands of pages of documents the night before, cross-examining on the next day. It's memorable for a number of reasons. Firstly, because of the result. It was proven and it became obvious through the course of the trial, through the course of the inquest, that the position that had been maintained by the hospital was entirely untenable. And there had in fact been really significant failings, which had affected not only Harry's death, but other children's deaths in that hospital over a number of years, and that there had been consistent warnings about what ultimately happened in Harry's case. So it was quite a remarkable outcome, given the position that we were faced with in advance of the trial. And so that's, you know, it was lovely in a sense to have that outcome. But I don't think that's what makes it the most memorable. I think at a personal level, it was extraordinary to work so closely with a family who'd been affected by such a tragedy and who had been faced with absolute stonewalling from the public authorities, who had a duty to be clear and transparent about what had happened. It simply wouldn't have been possible for them, incredible and courageous as they are, to have conducted that process without legal representation. And the privilege of working with them at an individual level and being able to be there for them, whatever the outcome, is something I will never ever forget. I mean, it was remarkable in so many ways. So that's my first. The second is quite different because it was memorable to me because of the systemic issues it raised. It was an issue of principle. It was a case brought by the End Violence Against Women Coalition, which is a coalition of NGOs and rape victims. And it was brought against what was said to be a change in policy by the Crown Prosecution Service in respect of rape victims. And what we maintained was that there had been a precipitous drop in the prosecutions of rape and that had been sparked by a change in policy at the CPS. It was an extraordinary case for many reasons. It was hundreds and thousands of hours of work going through policy guidelines. There were whistleblowers involved. And as the junior counsel on the case, I was responsible for sort of putting it together and shaping what appeared to be emerging as a problem. Now that's not actually a boast, as you'll work out when you hear the results of the case, because ultimately we weren't successful in the court. And I think a little like Patrick, it was a loss, but it wasn't a loss. I like to think that there was a national conversation sparked about the prosecution of rape from that case. And there was a huge amount of public scrutiny applied to what had happened. And ultimately, all of the changes that we had sought in the judicial review were made by the CPS, not by way of settlement, to be clear, but they were made separately. So it was a loss, but it wasn't a loss. But in a sense, one of the reasons that I think it's memorable for me is actually because we lost. It was heartbreaking to me. I had put thousands of hours into a case that I thought was meritorious, strongly meritorious, and which was dealing with hugely impactful decisions on individuals' lives at a systemic nationwide level. It was something that you could hear on the radio when you were going into court and that kind of thing. And I think it goes back to the fact that you have to do this whatever the outcome. You can win and you can lose, and it's still really important to be able to be part of that conversation. And it's a privilege to be part of that conversation in the areas that I work in. As with Patrick and Deirdre, you can shape the course of public policy. Ultimately, we didn't. There was no changes forced through the case itself, but again, it was an experience that I'll never forget, and I'll certainly never regret.
Thank you all so much for those really touching comments and cases. In light of the importance of the cases you've talked about, it's easy to see why you want to do pro bono, but it's difficult because by definition, pro bono doesn't pay the bills, and we all have bills that need to be paid. So how do you all balance the need to undertake paid work, but also the desire to do pro bono work?
Well, it depends a little bit on the nature of your practice. If you are simply going from court to court, maybe even doing 2 cases a day when you start, and you're preparing overnight for the next court day, it's much more difficult because you really have to make a positive choice to turn away other work in order to create the space for doing true pro bono work. If you have a rather more mixed practice where you do have gaps in attending a court, you're advising, you're preparing for other cases, it's easier to sort of to squeeze in. I should say, and I hope this has changed, I think it has changed, that your old-fashioned barristers' clerks from sort of sitcoms about barristers' chambers were very powerful figures, and they are still very powerful, but they're now much more sensitive and socially aware. They didn't used to be. And I think one reason why Jennifer in the old time would 20, 30, 40 years ago have actually kept quiet about doing pro bono work. You'd have almost had to lie to your clerk to say you needed time off and that you got, because they are supposed to be protecting the financial interests of the chambers and you're not earning money, they're not getting their percentage, your colleague, etc. It's different now. And so perhaps I shouldn't mention it. I'm very confident it's different. But I should finally say that, and it's been hinted already, you're inevitably doing pro bono work if you're doing legal aid work, because it is so badly paid. And if you're going to do a professional and committed and proper job, you are working way beyond the hours that legal aid will allow, have allocated in civil cases, and for very low hourly rates. In criminal cases, for example, even now, you don't get paid for reading the unused material, which can be critical. In all my experience over 40 plus years of miscarriage of justice cases, the single theme, there will be others together with them, but the single theme which appears in almost every single case is failures in the duty of disclosure. And you can spot those through the gaps in the unused material, which are very often thousands of pages of material, a reference to another document which is missing or to another witness. And if you ask the right questions, you might get it. And notoriously, I think only the other year, an extraordinarily committed woman defense lawyer in a case literally, put her children to bed and said, the day before I realized what was going on, I worked until 2 in the morning going through this unused material. Now, she wasn't being paid a penny for doing that. And she cracked the case, and it made national headlines because the case was a scandalous one. So if you're doing legal aid, there's no divide. You're doing pro bono work already.
I think that the advocate, what used to be the Bar Pro Bono Unit, tries to encourage barristers to do about 10 to 15 hours pro bono a year. If you take on any sort of pro bono case, you will meet that target very easily. I suppose when you're starting out, there's a balance to be struck between taking on a lot of pro bono work and establishing yourself. But I think it's reasonable during the course of your year in practice to expect to take on 2 or 3 cases. I have to say in my own practice, I tend to do about 10 to 12 cases a year. Sometimes I do more. And it very much varies. You might just do a one-day hearing. You might do a case in the Supreme Court, which requires 2-3 weeks of preparation. You might just turn up to represent somebody in a particular context. I think it's all about balance. It is a privilege, of course, to represent clients and to have the opportunity to assist them, but sometimes it's not practical. And I think when people are starting out, you have to strike that balance because you have to earn a living for yourself. In better paid areas of practice, in more commercial practice, there is perhaps an opportunity to take on some human rights work and to assist clients with your forensic skills, which are honed from commercial practice, and to take on those cases. And that it seems that I know from what Jennifer has said, that seems to be quite a common practice in my experience. So it's a balance. When I think at the trainee stage, at many law firms in the city and many barristers' chambers, and before you get into that stage, do encourage junior colleagues to take on pro bono work for the reasons of experience that we've all spoken about. So at different stages of your career, your availability and your capacity, I think, will vary. But I suppose one of the things I would encourage all of you who are listening this evening, most of us as we travel through life, we lose a bit of our idealism and we're not able to carry on with many of the aims and the objectives that we have. What I think is fundamentally important when you embark on your career, you have that idealism and that commitment. But the real challenge is to keep that with you throughout your career and to always be willing and always to be available to take on those cases for people who need you to take them on and not to forget the importance of that.
I mean, for my part, the question of balancing paid work and pro bono work is really just a question of how you manage your practice generally. And that's a difficult thing to do. It's a difficult thing to do at the junior end, in my experience. My impression from the constantly complaining people around me at every level is that it doesn't get any easier as you get any more senior. It's difficult to manage one's practice to properly reflect work and life, and to make sure you have enough work but not too much work. It's a juggling act that all self-employed barristers have, I think. As to juggling unpaid work with paid work, I am very conscious that I'm in a very privileged position. I'm in a set of chambers that has a lot of commercial work, so I don't have quite the financial constraints that the vast majority of the bar do. But ultimately, that choice is a choice that you have as an individual practitioner. And it's a choice that you can make at any stage of your career, including at the beginning. And it takes a bit of courage and often a bit of persuasion to people around you. But if it's something that you want to do, the great thing about the bar is you can do it, and there's nothing to stop you at all. So you juggle it with integrity as you would any other case. And one thing I would say, which I think is really important, is if you are taking on pro bono work, I have a great deal of criticism for those who take it on and treat it differently to other work. I was on a call recently where it was mentioned that we're doing this pro bono case, but obviously it's entirely secondary to all of our paid work, which I took quite significant objection to. As a barrister, it's your professional obligation to properly represent your client in whatever case it is. So you need to make sure you have time for those clients and only take on that work if you have time for them. And then I treat them as the same as any other case.
So perhaps I'll ask a follow-on question from that, which touches on some of the answers already given. And the question is, why do you want to do pro bono work? And perhaps I could ask you to focus more on the small scale work. You know, one can understand to a degree why people want to do high profile cases which enhance their reputation. But how do you motivate yourselves? Do you motivate yourselves, and why, to do the small scale cases that aren't going to get in the national press?
Well, the foundation of the cab rank rule, the bar, is the famous dictum of Lord Erskine, who was Lord Chancellor centuries ago, that, and I do it from memory here, let no man go undefended against the power of the state. And that is actually the foundation of one of the great principles of the bar. And surely it evidences the importance of remedying a gross imbalance of resources and of access to justice. Now, who is a human being could want motivation, who is aware of the story Jennifer has told and is the very general picture, and has been for very many decades, of the family of somebody who has died, a child in hospital, a spouse, family member, a friend, or somebody who has died in custody in mysterious circumstances where there may have been misleading public statements or no public statements about what's happened. They have suspicions. There are no cameras about what happened. The police are defensive, and they turn up to an inquest court where there are, I mean, literally serried ranks of paid lawyers out of public funds who will represent the chief constable of the relevant police force, who will represent separately the individual police officers who may have separate interests. So there may be more than one barrister for more than one police officer, perhaps a lawyer for the police doctor or the custody doctor who turned up, who may have advised negligently or not. And there they are. And there they are with piles of documents, as it was. I mean, the pre-digital age, there literally would be boxes and boxes of documents. And the family have no idea what's in those documents. And all these lawyers are there, and the coroner runs the show, and they have nobody to represent them, nobody who explains the procedure satisfactorily to them. And they are told it's a non-adversarial process, and the coroner will look after their interests. It is deeply shocking, actually. It's something which many of us have been aware of for a long time and have tried to redress. And for instance, Jennifer referred to having thousands of pages of documents given to you overnight to prepare, and that is bad enough. But as it was, you wouldn't even get the thousands of pages of documents. So from my point of view, I can't need more motivation than to be aware that that is what is happening to bereaved family and friends of somebody who has died in circumstances which are impenetrable, but for our inquest process, with all its limitations anyway. And you have to feel an obligation to do what you can to remedy that imbalance. Exceptional funding can be available. I think that there's been some announced change just very, very recently about it, that it's far too little, far too rare. And of course, there are many more lawyers available in London and the Southeast than are available in many areas of the country. I apologise for that. That's my natural alarm thing comes on. And so there are deserts of justice here, where inquests are held up and down the country, and where literally the family have no chance even of obtaining pro bono representation. I find that really, really shocking.
I think day-to-day in family practice, it very often happens in two ways. One is that you may be representing clients who, for whatever reason, lose their funding. It might be that they have some money. They may be grandparents who want to care for a child who's the subject of care proceedings. They'll use their own funds and they'll run out. Or what often happens is colleagues are involved in proceedings. A grandparent or somebody else will need representation for a particular hearing, and they or a solicitor may contact you or chambers. That very often happens at all levels of practice and at the very junior level. It's part, I suppose, when you're looking at making that decision, it's part of recognising that you have the skill and the ability to help and to represent, and if you can do it, you want to do it. And very often, of course, if you've been representing clients and they run out of money, you're invested in the outcome for them. Day-to-day care cases in front of magistrates, in front of district judges, which is the business of the family courts. The outcomes of those cases are very important. People see their children, people don't see the children, people lose their children, children are adopted. And when you're representing a client through that process and they run out of funds or they're not able to get funding, it's just a human reaction that you want to continue to assist them if you can. So I think if I was to speak to junior colleagues and looking at my own work outside of what might be the more sort of headline grabbing elements, those cases are equally important. They're fundamental to the people that you're representing. And solicitors would often just call and say, look, there's a set of care proceedings, there's a grandmother, she needs to be represented for 3 days. Can you do it? Can somebody else do it? And all of the other reasons that we've spoken about in these discussions apply to those, but there's also your own, I suppose, sense of obligation and recognition of your the necessity of allowing your own skills to be used to help people in those situations. That I have to say, from my own experience, the bulk of our pro bono work is those sorts of scenarios. It isn't popping up in the Supreme Court.
And just to pick up on that final point, that most of the work is in smaller cases, in line with Lord Sale's question. I think for me, why would I do a small case? Well, a small case doesn't raise any less significant issues than a large one. As it turns out, you get the same tricky questions of law and of fact, where it's one person in a social security tribunal outside of London, as you do in the appellate courts. And as a junior, you get the responsibility to determine how those points are put across to the court, which for many people in certain areas of practice is something that you wouldn't otherwise get. I also think that as a junior, it can be a really good way of doing different types of practice, of expanding your practice. If you take small cases in different areas, you can start doing a little bit of different type of work, and then you can build up a sufficient reputation that you can then take on other types of work if you're sort of looking to move a little bit, or even just for some variety, which can be no bad thing sometimes in this job. And finally, I just echo what Deirdre said about small cases. They're often the most important to the individuals involved, and if you have faith in the rule of law and the rule of law applying to all equally, then there's no lesser imperative in doing one of those cases than there is in anything more glamorous. And you never know. The Harry Richford case was not considered to be a glamorous case when I took it on. It was just an inquest into a hospital death. but you never know what you might find.
Excellent, thank you very much. I'm going to skip to my last question because we are running a little bit short of time. So I'd like to ask you guys all what advice you have for students and young lawyers who want to get more involved in pro bono.
Well, Advocate is the pro bono organisation supported by the Bar Council. It is, if you want to call it, the sort of clearinghouse for members of the public to approach with a problem, and they have volunteers who sit there and condense the summaries and decide whether it should go anywhere, and try to find barristers in chambers to provide advice and representation. So go to Advocate, offer your services. You could start off by being one of their volunteers in their office doing the sifting, and then make it clear that you're willing to take on cases. But there's another way of volunteering in which you will learn a lot, make exceptionally good contacts for your practice if one's being self-serving, which is not a bad thing. There are wonderful NGOs, Justice, Liberty, Reprieve, and many other campaigning organisations which are exceptionally responsible and respected now. They put in briefing papers for debates in Parliament when when bills are presented, and you can play a part there. They're crying out for volunteers to do that work, and you will come across other young lawyers and solicitors who may brief you later. You may form lifelong professional relationships, I assure you, and very rewarding ones. So it's not just direct court work, but policy work you can do if you have the time to do it with all your other commitments.
I think I would agree with all of that, all of what Patrick has said. I think that the working with charities, the Air Centre, Family Rights Group, these are all organisations that rely to a huge extent on volunteers and interns. I still think FRU is always a very good organisation, and one of the real attractions of working for FRU is they do some very good training programs for you at the beginning of your practice or at the beginning of your work for them. So before you could take on cases, they do training. And I have to say, I found that training to be enormously helpful and beneficial. And then, as Patrick said, Advocate is always looking for assistance and volunteers. Wherever I turn in terms of work for charities or any sort of policy work, I'm always blown over by the extraordinary commitment of junior colleagues who are working as interns without pay. So those opportunities are there. And I think that they provide that doorstep or that gateway, if you like, into the profession. My impression also, but you all know better than I, is that there are clinical programs now in many of the universities. And again, getting involved in casework through the clinical programs is also a really wonderful opportunity.
Thank you all very much. I'll pass you over to Lord Sales for the final question from the chairs. And we've already got a couple of questions coming in from the audience, so we'll deal with those afterwards. Thank you.
Well, I'll ask you then, just to outline, if you can, what's the difference in the kind of pro bono work that is done by solicitors and by barristers? I appreciate that you're all on the bar side of doing the work, but you will, I'm sure, work with solicitors in various contexts who are also acting pro bono. And perhaps you could give the students an idea of how the work breaks down between the two when you're doing a pro bono case.
Those distinctions have blurred rather, and probably in the public interest. Conventionally, of course, a solicitor does the solicitor's work, the groundwork and the investigation, and then briefs counsel. But first of all, of course, there are many solicitor advocates now who will do pro bono work, and they won't come to counsel at all. And the solicitor advocates are wonderful. The second development is direct access for barristers, so that no solicitor is involved at all now. There are certain limitations to that. There are certain things that barristers aren't allowed to do. But at least, I suppose, if you're acting pro bono, there's no question of holding funds or anything, which are complications which limit direct access work. It's not such a clear distinction. And frankly, if it's pro bono, you can work as a team and completely break down that barrier. If you have a solicitor and a barrister, you start at the same time, at the same level, and you get the papers at the same time, you can split the work, and you're splitting the preparation and the advice and advocacy. So it can be teamwork. So I would say this isn't necessarily an absolutely clear distinction as it used to be.
I think in many ways, when you take on a pro bono case and you're working with a solicitor, the division of labour is the same as in a case in which you are getting paid. But the only thing I would just alert colleagues to is that I think increasingly in legal aid firms, it's just not possible to take on, in addition to the legal aid work, as Patrick has pointed out, which is very underpaid, places huge challenges, I think, for firms to make money. It's really not possible for solicitors to take on pro bono work. And very often when I'm looking for a home, if you like, for a pro bono case, I'll think very carefully before burdening a solicitor with the work, because it just isn't, there isn't the room in the day for it. But in my experience, most of the time, it's that commitment, which means that solicitors and counsel will work the case as they work any other case. And Jennifer has made the very important point that we shouldn't be taking it on unless we're going to do that. And in my experience, people do. But it's been, in my experience, the same division of labour. So the solicitor will do a lot of the front of housework with the client, a lot of the management of the client. And in the area where I practice, of course, clients are very often very distressed. They need a lot of assistance and support. And solicitors doing that pro bono are heroic, in my view, because as counsel, we come on board at various stages of the case and do the strategy and the legwork and the research, but managing the client. And I think one of the points to make, somebody may have said this, but if they haven't, I will. We don't want to be too sort of dewy-eyed about pro bono work. It's as challenging as any other kind of work. I've had clients I've acted for pro bono who have been deeply unpleasant to me, who have behaved very badly, who walk away at the end of the case without so much as by your leave. And for solicitors dealing with that, phone calls with clients getting angry, clients getting upset, you know, it's hard enough to deal with that when you're getting paid to do it. When you're not, it's a real challenge. But I think it's important to remember that just because the issues that arise in the case are important and consequential, clients don't behave in a saintly way. Clients are always challenging, and you need to be alive to that when you take on the work.
I think the only thing I would add to that is obviously solicitors have a much broader spectrum of work than barristers. What Patrick and Deirdre have talked about is litigation and how solicitors assist with pro bono litigation. But there's obviously a huge amount of work that's undertaken by solicitors, for example, in property transactions, in access to benefits, in lots of family law arrangements, even in company or commercial transactions at small levels that can be done pro bono. And the vast majority of that sort of more transactional work is undertaken by those who are specialists in that kind of work, who tend to be solicitors. So I sit, for example, on the board of charities, and most of the work that's done for charitable organisations is done by solicitors pro bono. So even if you don't end up being a litigator, there's a great deal of opportunity to put your legal skills to work for people who wouldn't otherwise be able to pay. That's not necessarily the type of litigation that we've talked about this evening.
Thank you very much. So before we go to the audience questions, I've just put a Microsoft form into the chat box. We were really delighted by the people who were interested both in presenting as panelists and chair, but also the number of students that were happy to give up their Friday nights. And we're very much wanting this to be the start of an ongoing series of events focused on encouraging students and young solicitors and barristers to engage in pro bono work. So the form that I've just put in the chat asks you all to give your feedback and tell us what kind of events you'd like to see in the future. Hopefully in person in the future, but we would love your feedback on the different forms and the different ideas. So please do consider doing that while we do our questions. So I have a number of questions that have come in from the both Q&A. I've also got questions that have come in to me personally through the chat, but if you could avoid doing that because I might overlook them, and if you could keep them to the Q&As, it would just be a little bit easier. So thank you very much. The first question we have is from Catherine Drummond from University of Cambridge. And Catherine says, thank you to all the panelists for your remarks. It's really fantastic to hear about your important pro bono work. I have two questions that relate to how NGOs feature in your pro bono work. Firstly, how does doing pro bono work for NGOs differ from pro bono work for individual clients? And secondly, is perhaps for Jennifer, who has said she's done pro bono works before the UN human rights bodies. In situations where NGOs are helping individuals based overseas, who perhaps do not speak English, and those NGOs bring pro bono cases to you, are there any ethical issues involved with trying to get instructions through NGOs? Because, Jennifer, there's one specifically directed at you, maybe we could flip the order and Jennifer could go first and we'll finish with Patrick, if that's all right.
Sure. I mean, when it comes to whether pro bono with NGOs is different to pro bono for individual clients, it's difficult to make generalizations because there's a wide spectrum of individuals and a wide spectrum of NGOs, but one tends to find that the NGOs have a more structured approach to litigation. They tend to be thinking more strategically about issues that they wish to challenge at a systemic level, and they often have a great deal of expertise themselves. So you're often working with real experts in that area. So there's often quite a sort of horizontal relationship in terms of expertise, whereas obviously on the individual side, that's far less likely, although it's not impossible. And also NGOs, for the same reasons, because they're organised and they're often sort of well tooled up about this stuff, that they're much more aware of things like cost risk and that kind of thing. They're much more structured in their thinking and their decision making, whereas individuals tend to have been forced into a position where they feel like they need that help. Again, that's a generalization, but tends to be the case. As to ethical issues with working on international cases with individual clients from other countries, it's very difficult to make generalizations. I've got cases on behalf of individuals against states where I've met those individuals and taken instructions alongside my solicitor from them directly. But I think it's right to recognise that there are professional ethic issues and also potentially sort of more broader moral issues as to the way one works with individuals and organisations from other countries, and trying to make sure that the advice and representation that's given is not taking power away from those in those circumstances, and making sure that you're supporting rather than taking over from local NGOs, if that's the brief. And yeah, trying as best one can to satisfy oneself that the instructions you're receiving are proper and have been bottomed out properly. But it's practically more difficult than one finds often in England and Wales, but it's not actually principally any different in terms of what you're trying to do. You need to satisfy yourself professionally that you have full instructions and you're presenting the full picture to the court, and that's practically complicated, but it's no different to any other case. And I'm sure in Patrick and Deirdre's practice they've had experience of trying to find clients and what they actually think about the case that's being brought to them by a solicitor. It's something that does arise, not just in that area.
I think I would echo those comments. I mean, the situation, I think, with NGOs is that they have to be very thoughtful and very strategic about litigation. And when an opportunity presents itself for an NGO to become involved in proceedings, it will be because they want to run an issue out and have it come back in terms of their policy. But in my experience, particularly NGOs who become involved in third-party interventions, they're very careful. They have to be very focused about the part of the case that they're going to intervene on. And the court, certainly at appellate level, will confine the NGO to its own lane. So you stay in your own lane. One of the things which I think is in some ways very enjoyable about acting for an NGO, but it's also quite challenging, is that you have to remember that you're invariably neutral as to the outcome of the case, and you'll be making submissions as to points of law. And I mean, others, obviously Lord Sales and others will be better able to speak to this. But one of the interesting things is, of course, the court filters out the NGOs at the application stage. You might make an application, as I've done, to intervene on behalf of an organisation, and the court will say, no, that's not helpful to us. So the court is making a decision as to whether it thinks interventions on those particular points or from organisations with that particular expertise is going to assist. And in some ways, you don't bear the burden of the case. You're not advocating for a particular outcome, but you will have an eye on the policy objectives that the NGO is seeking to achieve. And sometimes, I suppose, the other point just to mention is that cases on fundamental points of law or key interpretive provisions of legislation or key interpretations of provisions of legislation, they don't come around very often. So when an NGO has that opportunity to intervene in a case, they want to get it right, and they want to try to steer, the legal interpretation in a particular direction. So you have to bear that in mind when you take it on, and be sure that you're equipped and able to contribute to that discussion.
The very positive aspects of the role of an NGO in litigation is that they start with access to relevant experts who may well be members of their organising panel, and also to all the international research on the question. So just to take one example, they will instantly be aware of the international standards on the Istanbul protocols on interviewing alleged victims of torture. And so any barrister coming into a new area is automatically ratcheted up in their ability to cope with the issues. So those are very big advantages. Mention has been made of the sifting by the Supreme Court, particularly of contributions, interventions from NGOs. Very often when it is allowed, it's allowed on paper, and it's for Lord Sales to say, but certainly I have a very positive impression from remarks made by the court in their judgments that their interventions have no lesser impact on the deliberations of the court because they're on paper, and the court pays very close attention and respects their expertise.
Should I just say something very quickly about that? I mean, 2 points I would emphasize so far as NGO work is concerned. First, as Deirdre and Jennifer were emphasizing, they have to take a strategic view in relation to litigation. They have wider policy aims, they have limited resources. They can't function as some sort of legal aid substitute. And they have to find the cases where they think they will make maximum impact in terms of presenting and advancing their policy aims. So they do tend to go, I would think, more for the high profile cases, but for obvious reasons. The second thing is in relation to the perception of interventions from a judicial point of view. Patrick's absolutely right that written interventions are often of equal weight, if not sometimes more weight than an oral intervention. The court's very aware that a written intervention from an NGO will have been carefully thought over, considered, and it does have a limited function. And very occasionally, some interventions sort of overstep the mark, and they read as though they think, well, this is a case for them. And they range far and wide, or can do, in the submissions that they make, which go beyond the submissions being made by the parties, whereas their true function is to assist the court, and from a relatively neutral perspective on the arguments that are actually before the court. But that doesn't happen very often. For the most part, in my experience, senior courts in particular find it very useful having considered contributions from a range of NGOs.
Thank you all very much. We have 4 minutes for the final question, which is a really interesting but a bit of a tricky one. And so this one has been sent to me through the chat anonymously, but it says, thank you all very much for your insights. Considering your comments about pro bono being a professional organisation, a professional obligation, do you agree that we should have mandatory quotas for pro bono work for all legal representatives working in the UK? So we might go in the same order, and we'll finish with Lord Sales. And if you could keep your remarks to about a minute each, I'm sorry, guys. Thank you.
I don't actually think that. It is the case in the US, for example. I think it's a bit unstructured as a way to deal with it. I think it places a great obligation on, for example, legal aid practitioners who are often doing the most good, but getting paid the least, to then be forced to have a certain quota. I think there should be a great deal of encouragement for this kind of work. But I think in light of everybody's self-employment and differing circumstances and the lack of general support available at the bar, a mandatory obligation would not be fair.
I agree. I don't think we should have it. I think it would be wrong to impose it on people. But one of the things that I think we can say with some justification is there's no need, because both branches of the profession and all of the students and trainees have come forward and provided pro bono assistance as is necessary. So I don't think that's a road we want to go down. People should do this because they want to, and they do.
Well, one way, I entirely agree, there shouldn't be an across-the-board obligation. The one way in which it might operate is when the Solicitors Regulation Authority find firms of solicitors in London are complicit in money laundering and offences like that, from which they are making enormous fees. Now, part of the penalty for that, interestingly, perhaps could be an obligation for them to devote, 200 hours of their firm's time on pro bono work in the following 12 months.
I agree with the position of everyone else. I entirely agree with what Jennifer said. I think no obligation, but maximum encouragement for involvement in pro bono work.
Fabulous. And what wonderful words to end today's session with: maximum encouragement for pro bono work. So thank you all very much for coming. It's been such a moving and wonderful way to spend a Friday evening with you all. Just a quick reminder, if you could complete the Microsoft form that's in chat, it would really help us with our future plans for developing this series further. And I'd just like to thank you all for coming. I'd like to very much thank and recognise the incredible work of Amelia, Charlotte and Charmaine, who organised this event whilst doing incredibly stressful and time-consuming studies. So they should all be very much congratulated for their commitment. I'd like to thank Lord Sales for coming and speaking so passionately about it, and to our 3 panellists, Patrick, Deirdre and Jennifer. It's really inspiring to hear your stories and to see the commitment that you guys have to using your skills to make the world a better place. So thank you all for coming, and I really hope to see you all again in person for the next event. Have a wonderful weekend and stay safe. Thank you.
And you. So, cheers.